Hi, everyone. Welcome to the 2023 Hot Topics in Environmental Law Summer Lecture Series. I'm Jenny Rushlow, Dean of Vermont School for the Environment, and we're very pleased to welcome you today. I want to acknowledge off the bat, it's been an incredibly difficult week in Vermont, and I just want to wish well to everybody who's joining us from various points in Vermont that are impacted by the floods. So for today's talk, each of these talks is worth 1 Vermont CLE credit. And if you'd like to claim that credit, you'll just need to keep track for your records. We'll have time for Q&A after today's presentation. And if you're watching on the VLGS YouTube or Facebook sites, you can enter your questions in the chat or the comment space at any time during the talk. And we'll get through as many of those questions as we can. Today, we're very pleased to welcome Sean Donahue. Sean is a partner at Donahue and Goldberg, where his practice is focused on appellate litigation, with a focus on complex environmental and administrative law cases in federal and state appellate courts. And Sean is modest, but he regularly appears before the U.S. Supreme Court specifically. He's a graduate of the University of Chicago Law School, and he served as a law clerk to the then DC Circuit Judge Ruth Bader Ginsburg, as well as to Justice John Paul Stevens. He practiced at the law firm Jenner and Block, where he spent 4 years at the appellate, and after practicing at Jenner and Block, he spent 4 years at the appellate division of the Department of Justice, Environmental and Natural Resources Division. He established his own practice in 2002, and since doing so has represented environmental and public health organization parties in numerous major environmental and clean energy cases in the Supreme Court and courts of appeals. Here at Vermont Law Graduate School, he taught a course this month called Environmental Appeals in our summer session. And today he'll give a talk titled West Virginia v. EPA's Major Questions Doctrine Turns 1, an Assessment. Please join me in welcoming Sean Donahue.
Thank you so much, Dean Rushlow. And I want to echo what you said about just thinking about everybody in Vermont. I've seen the images of Montpelier, and I know it's really rough in a lot of the state. So wishing everybody a safe week, and hope things dry out soon. So I wanted to just say a little bit about what West Virginia held. I actually gave a talk last year that was just 2 weeks, I think, after the decision, and I worked on that litigation for many years. It was the litigation over the Obama administration's Clean Power Plan. Complex rule adopted under the Clean Air Act designed to reduce carbon dioxide emissions from coal and gas-fired power plants. And so it was a painful blow, the Supreme Court decision last year. I've now had a year to let it partially heal and reflect on it a little bit. And it's perhaps a little bit less painful. But I wanted to talk about sort of what's happened with the potentially very consequential legal doctrine that West Virginia relies on, and sort of look at what's happened in the lower courts over this year with that so-called major questions doctrine, and then look a little bit at the Supreme Court's most recent major questions decision, which was the student loan forgiveness case, Nebraska, or Biden versus Nebraska, and then talk a little bit about sort of where things might go from here, and what I'm looking out at with the future of major questions. So just a word about what West Virginia held. This was a long-standing dispute over whether the Obama administration had the authority under the Clean Air Act to adopt this rule, which attempted to sort of build upon the trends in the power sector toward greater use of lower emitting and zero emitting power generation sources, gas plants taking over for coal plants, and renewables taking over for fossil plants. And the EPA based its determination of the best system of emission reduction, which is sort of the key concept under the statute, under Section 111 of the Clean Air Act, on the ability of sources to shift from dirtier to cleaner generation. Had a lot of support from industry and a lot of support in what had already been observed in states that were regulating carbon. The rule had a long and complex litigation history, including a Supreme Court stay and then a decision of the DC Circuit on the eve of Joe Biden's inauguration, holding that the Trump administration had relied on an overly restrictive understanding of the Clean Air Act in repealing the Clean Power Plan, and that in fact the sort of legal construct of best system that the Obama administration had relied on was lawful. It was something of a surprise that the court took the case, because it was clear that the Clean Power Plan was never going to be implemented. It had been sort of bypassed by events. The emission limits were no longer relevant because emissions had dropped below them just from operation of market forces and state laws. The Biden administration had indicated it planned to replace the rule. So the court's grant of cert was regarded as kind of a sign that the court was eager to get at the sort of statutory authority questions, and probably a bad sign for advocates of broader EPA authority. And indeed, that premonition was borne out. The court, in a 6-3 decision with the 6 conservatives in the majority, held that the Clean Power Plan was unlawful, and therefore the DC Circuit was wrong to conclude that that the repeal of the Clean Power Plan was based on a mistake of law. The court's decision, rather than beginning with a sort of microscopic analysis of the statute, which is the way a lot of the case had been argued and the way the DC Circuit sort of analyzed the question, begins with a discussion of this principle that the court endorsed as such for the first time, the major questions doctrine. The court relied on a series of cases that it said were very analogous and basically reflected the same principle, but a majority of the Supreme Court had never called these cases a common thing, the major questions doctrine. And the court said, in some extraordinary cases, where an agency is claiming very, very broad authority that is not something that it has claimed before, we hesitate before concluding that Congress has given the agency that kind of power. It talked about cases like Brown and Williamson, the case about regulation of tobacco, and the more recently, the case about the COVID motivated eviction moratorium that the court had struck down, and it said this principle is triggered here. The court regarded the Clean Power Plan as an extremely ambitious sort of top-down effort at reducing carbon from the entire power sector and sort of decreeing a goal instead of building from the bottom up, looking at what individual plants can do to reduce pollution. And it saw the program as essentially a cap and trade program, much like the ones the Obama administration had tried to enact years before. They saw it as kind of a workaround for a failure to get legislation. And the court relied on a series of factors in concluding that this major questions doctrine applied. The scope of the authority claimed, which it characterized as sort of the scope to the authority to restructure the electric industry in the United States, a sweeping power, economically and politically significant. The novelty of the power claim, the court concluded that EPA had never done anything like this. All the prior rules under Section 111 had been more sort of humdrum efforts to identify particular technologies to base emission limits on, rather than this ambitious concept of generation shifting from to entirely different types of plants. And then it looked at other factors, such as whether the type of rule takes the agency outside of its sort of core authority. And it thought that that was the case with the Clean Power Plan, because EPA was sort of getting into areas of electricity supply that are more the authority of FERC or state public utility commissions. It also emphasized that it regarded the particular provision of the act that EPA was relying on, Section 111D, as a relatively little used, it called it an ancillary provision. It cited the failed cap and trade, the Waxman-Markey bill, and cited that as kind of evidence that this is an agency trying to compensate for something that could have been or should have been done by the legislature. And it also mentioned sort of political controversy, that this is a great debate about how to handle carbon in our economy and our political system. And the Waxman-Markey debate and the failed legislation sort of was proof of that. And so it's not right for an agency to step in and kind of do the very thing that Congress tried to do and failed. And so all of those factors, in a fairly gestalt manner, in other words, the court sort of cited all these things as supporting its conclusion. It didn't explain whether any one of these factors was sufficient, whether all of them were necessary, but it kind of cited them all as reasons why the major questions principle should apply to the question of EPA's authority to adopt the Clean Power Plan. And what did that mean? That meant that there had to be a pointed indication in the statute. There had to be a sign that Congress had clearly authorized this sort of regulatory action. And the court said, best system of emission reduction, sure. In isolation, that's broad, and it's plausible to say it could embrace something like generation shifting, but it's not in context. It's not nearly specific enough to persuade us that Congress meant to give over to EPA this massive power to regulate the power sector and restructure it. So that's the majority. And there was also a concurring opinion from Justice Gorsuch, joined by Justices Alito and Thomas, that sort of built upon the majority, but went further and described what the majority had relied on as a clear statement rule, and explained that in Justice Gorsuch's view, the major questions rule is based upon the Constitution, on the separation of powers, and the principle that the legislature and not an administrative agency should be making the law. And so it's a principle that if the statute is not extremely clear, and the agency's trying to do something big, a court should deny the agency the power, because otherwise it's an arrogation of legislative power that the Constitution vests only in Congress. And so there's that somewhat different view. It articulates a particular theory as to what's motivating major questions that is not articulated in the majority. So we'll come back to the significance of that separate opinion joined by just three justices in a bit. Justice Kagan, writing for herself and the two other liberal justices, writes a pretty scathing dissent and calls the use of the major questions principle a departure from textualism. She calls it a get out of text free card because she says the majority basically omits that best system of emission reduction, kind of embraces what EPA was trying to do. And she kind of said, this is extremely sensible. This is what industry wants. It's lower cost, more effective. We shouldn't make up reasons to deny EPA the authority to do this. And she characterized the majority's opinion not as protecting Congress by keeping EPA from doing things that Congress should be doing, but as harming Congress by basically not allowing it to use a broad delegation to allow the agency, its chosen agent, to respond to a complex problem like climate change and the power sector in an appropriate way, and that you're sort of hobbling Congress by imposing this sort of specificity requirement. So a very strongly worded dissent, or there's a lot of distance between the dissent and the other 6 justices. So so just some questions that seemed to loom large after this decision. One is, is this a new rule? Is this the supermajority Supreme Court with the 3 Trump appointees, going off on a new project to dismantle the administrative state or just undo things that a relatively liberal administration is trying to do? Or, as the majority says, is this application of principles going back to Brown and Williamson and a whole bunch of other cases that you kind of look at the overall context of legislation, and even Justice Breyer, when he was a First Circuit judge, had written a law review article sort of embracing the principle that it kind of makes sense that Congress would delegate the details, but really big questions it would probably want to decide itself. So there was some sort of bipartisan buy-in to this, and there were a variety of cases that weren't just deregulation cases that adopted various variations on this theory that if the agency is doing something really big and novel, maybe Congress didn't intend to allow it in the first place. So that's a question. How much is this new, and how much is this a continuation of principles that were already sort of pretty well settled in the court's statutory construction jurisprudence? And then another big question: what is the basis of the major questions doctrine? Is it a canon of interpreting and trying to find Congress's intent, so that we look at all the circumstances, we look at whether someone is, whether the agency is doing something really big and surprising, and maybe that's a reason to think, that's probably not what Congress meant, because it just would be really surprising if they enacted something that big with just a little tiny provision, the kind of no elephants in mouse holes principle that the court had applied in a variety of cases without a really strong sort of ideological or philosophical basis before, just kind of we're trying to get the meaning of the statute? Or is it, as Justice Gorsuch very energetically urged, a rule coming out of the separation of powers that is substantive, that basically allows a court to override what even might be the best reading of a statute if it implicates this concern about delegation, about giving an agency authority to do things that really Congress should be doing? And after West Virginia, that question isn't really answered, because we have the 3 justice concurrence, and we have a majority opinion that doesn't really say exactly. There's ingredients of both the kind of, this is just an interpretive rule about congressional intent, and there's elements that this is a separation of powers protection. So that's another big thing that's kind of yet to be worked out. And then I mentioned a whole series of factors, such as the scope of the authority, the economic and political significance, the novelty or not of what the agency's trying to do, whether it's within its traditional expertise, whether there has been failed legislation on this matter before, political controversy. What is the role of those factors going forward? Do they all have to be present for it to be a major question and subject to this rule of sort of heightened specificity? Or is it enough if one or two of them are present, at least if they're present, to a very great degree? And then, so those are just some of the questions that are kind of hanging unresolved after West Virginia. And so I'm now going to just briefly talk about what we've seen in the lower courts in the year since that decision. And I'm drawing on work by Natasha Brunstein at NYU, who's done a lot of great work on figuring out what major questions means, and is coming out with an article that will be in the Administrative Law Review, sort of taking a look at what's happened in the lower courts. And she finds, perhaps not surprisingly, given what I've said already, that there hasn't been a sort of consistent application of the doctrine in the lower courts. There have been vastly different approaches and sort of a grab bag of different factors applied in different ways, perhaps suggesting that there's more work to do, particularly at the Supreme Court level, in sort of clarifying what this doctrine covers and doesn't. She finds, at least tentatively, that there may be a sort of partisan political valence to the outcomes and application of the major questions doctrine. That she finds out of 21 major questions decisions through the middle of June of this year, 8 of them Court of Appeals and 13 District Court. 9 cases in which Democratic appointees upheld Biden administration actions, 7 cases in which Republican appointees invalidated Biden administration actions. She also found, somewhat interestingly, that she looked at which opinion are the lower courts citing to. You would think it would be just the majorities, and that is true in most of the cases. 16 of them, she found that the lower courts applied the West Virginia majority, but she found 5 cases in which district court judges relied on the Gorsuch concurring opinion, and those were all Republican appointed district judges. So I don't know if one would call that a valid sample, but I think as a litigator, there is very much a sense that this doctrine is now regarded as a tool for opponents of regulation, particularly environmental regulation, particularly climate regulation, and as a serious obstacle for the Biden administration, and that it is a tool that is particularly potent when the deciding court is inclined to be skeptical of regulation. So you've perhaps seen there have been some pieces about forum shopping and even judge shopping, where there's only a single judge in a district, and there is a concern that very open-ended doctrines like this, where there are a whole bunch of factors, even Justice Kavanaugh, when he was on the DC Circuit, and espoused adoption of major questions as a doctrine, acknowledge that there's a kind of we know it when we see it quality to it. And so you can imagine why defenders of regulations are worried about how that doctrine is going to be used when in the hands of judges who are instinctively very skeptical of regulation. Just the more discretion there is, the more people, and it's human nature, more people are likely to decide things in accord with their prior beliefs or commitments, even if they're trying not to. Okay, and Natasha Brunstein notes at least a couple of cases where there's a sort of a troublingly undisciplined sort of adaptation of the doctrine, like a case in which a court just kind of characterizes a rule as this says, this is an important policy decision, therefore major questions should govern, which is, of course, considerably less sort of detailed and rigorous a test than even the West Virginia majority opinion. There was also a case involving the Deferred Action for Childhood Applicants, or DACA program, in which a court relied on supporters' claims that DACA had big benefits for the economy as a reason to declare it a major question. This is a big deal, whether it's benefits or costs, that shows that this should be something done by Congress. Perhaps the area where there's the most sort of defined lower court law on this is on whether the doctrine applies to procurement regulations. There's a circuit split on that, with 3 courts of appeals saying it does, and 1 saying it doesn't. The argument against it is that this is an area where presidential authority and discretion has always loomed especially large. The argument for it is, this is another area where an agency or the president is interpreting and applying a statute, and the same principles should apply. That was, I think all those cases were COVID related rules applicable to federal contractors. I think it's fair to say we haven't gotten a lot of guidance on some of those questions that I mentioned. What is the role of the factors? What weight should they have? Are they, all necessary, or is it enough to have a couple of them? And how strongly should they appear before the doctrine applies? There have been some efforts to kind of figure out what's the common element in these cases and sort of boil it down to a test, or at least a kind of minimum that you must show to establish the major questions test. And one of those is that at least the agency's policy or rule has to be reflect an unheralded and transformational exercise of authority. So unheralded means it was not done before, it's new, and transformational is the agency's exercising not just making a new rule, but exercising a new kind of power. I think we haven't seen from the courts yet, and that was actually Natasha Brunstein and Donald Goodson law review article, sort of distilling West Virginia and some of the other cases. We haven't seen courts, I think, sort of lay out limiting principles, I guess I'd say, and somewhat ironically, because part of the major questions doctrine is to ask whether the agency's view of its power is cabined in some way that will make the court comfortable that it doesn't sweep too broadly. One might well say that the major questions doctrine is subject to the same concern. An area that is of great concern to me and clients that I represent is arguments that just the sheer size of a rule is enough. In other words, if there's enough money at stake, if compliance costs are large enough, if it's just an important thing, then all of a sudden major questions applies. I don't think we have case law suggesting that the test is quite that malleable or weak or universal, and we do have the repeated insistence in the majority opinion that it is a rule for extraordinary cases that would seem to cut against that kind of approach. But we do see litigants arguing that. I'll just say a little bit about the Nebraska decision. This was the student loan forgiveness case from just a couple weeks ago, in which the court held that the Department of Education had overstepped its authority under the HEROES Act to sort of create exceptions and waivers from a statute providing for the federal student loans. Unlike in West Virginia, the court begins with the majority, and this was another 6-3 decision. The majority begins with the text, and the sort of lion's share of the analysis is a textual analysis. The key words are waive or modify any provision of the statute. And the majority's view, neither of those terms, waive and modify, justified the sort of very broad forgiveness program. The majority saw what the department had done as sort of rewriting the statute, and it relied in part on a prior decision, MCI, that had focused on the word modify and said, just as a matter of common usage, modify means something sort of incremental, not something huge. And that was not what we face here. This is huge. But after having concluded that that the department's action was not authorized by statute, just looking at the text and structure and so forth and history, the court went on to say the major questions doctrine applies here and sort of reinforces our conclusion, and says, this is another sweepingly consequential agency action. The statutory text that it's based on is not sufficiently pointed and clear, and it is novel in, the agency had done very, very narrow waivers in the past, nothing like this in the court's view. And so the major questions framework should apply, and we should be asking for pointed statutory language. The court rejected a distinction that the government tried to make between regulatory law, like the Clean Air Act regulations at issue in West Virginia, and spending measures like forgiving loans. The government had argued, well, regulation raises special concerns about, oppressing private actors, et cetera, and this is sort of not that. The court rejected that and said, we've never drawn that distinction. There's no reason the major question shouldn't apply here. There is a significant constitutional concern here with the appropriations clause, which gives Congress, not the executive branch, the authority to appropriate money, and this kind of trenches on that. So major questions again. I think I will jump to the dissent. Justice Kagan's dissent is very much, again, for three justices, very much a reprise of her protest from West Virginia. She says, this is the get out of text free approach. The fact that you're relying on major question is sort of a tell that the actual language of the statute does authorize this, and you need some kind of extra sort of thumb on the scale to find that the agency has gone too far, and this is objectionable for many of the same reasons. And in her view, waive or modify was broad enough, and that Congress had adopted that language to give the Department of Education discretion to tailor relief to disasters like the COVID pandemic, and that's what Department of Education had done, and it was totally lawful. So pretty intense dissent, and she again is saying, the court is usurping the role of the politically accountable branches, Congress, which gave this broad power, and the executive under the president, which exercised it, and the court is sort of acting as the super legislature, and it's sort of very, very strong, and it actually prompts a protest from the Chief Justice, who wrote the majority opinion, saying, we can disagree about policies, but you shouldn't say we're not, acting as judges deciding the role. So you get a sense that this issue has brought up some pretty intense dispute within the court. There is a concurring opinion in Nebraska that is of quite a bit of interest, and that is from Justice Barrett, who sort of defends major questions, but puts a particular gloss on it. She reads it as a rule of interpreting language, as just a rule of taking account of context. She uses some homespun examples about shopping lists and instructions to babysitters, about how we would take into account sort of the stakes or the magnitude of the matter in interpreting words, and that's what the major questions doctrine does. She contrasts that to substantive canons like the clear statement rules for federalism and anti-retroactivity and some others, and she says that's not what this is, because those rules allow a court to reject the most plausible reading of a statute because of some substantive concern about impacts on states, and basically require Congress to be extra clear if it wants to do something that, say, impinges on a traditional area of state authority. She says that's not what major questions is. It's just an effort to get at what did Congress mean here, and part of what you do is think about context. She wrote just for herself, so it's not clear that view is commands broad support among the 6 conservatives. Her opinion gets cited somewhat in a somewhat friendly manner in the majority opinion, but not adopted. So I think when we compare the Barrett concurrence in Nebraska and the Gorsuch concurrence in West Virginia, we can see that within the 6 conservative justices, there is pretty marked difference of view about what's going on with major questions doctrine and where should it go and why is it a thing, which seems to suggest that there's going to be a need for some more case law to work all this out. I will just briefly mention another case from last term that was not technically a major questions case, but had a lot of the same flavor as Justice Kagan pointed out in her dissent in Nebraska, and that is the Sackett decision that my students from this summer will be all too familiar with, and from last summer too. In that case, the court rejected a longstanding government interpretation of the Clean Water Act, in part based on a canon of construction relating to sort of state authority over local land use and private property that seemed to kind of cut against a pretty straightforward textualist argument that the agencies had properly or reasonably read the Clean Water Act to cover the kinds of wetlands that were in dispute. So Justice Barrett joined that majority opinion, and I think I would say Sackett put together with these 2 major questions decisions, should be a great cause for concern for sort of environmental advocates, that the court does not, seems to see environmental law as, often going too far, especially regulation, and as warranting sort of control by the court. And in Sackett in particular, kind of remarkable that there was a very strong argument that the interpretation the majority adopted would sort of very substantially, and even Justice Kavanaugh dissented in the case and kind of pointed this out, very substantially undercut the core explicit purpose of the statute to protect waters of the United States. And that didn't seem to get weight in this kind of canon balancing. So definitely worth thinking about that one as well. Okay, I'm going to briefly talk about sort of the outlook going forward. As I hope has been clear from what I've said, There's a lot that is not yet resolved about how the doctrine works, even what its basic rationale is. There is plenty there for advocates or opponents of regulation to claim that almost any significant regulation violates the doctrine, and we're seeing that all the time. I think I said last year when the decision came out that lawyers in certain DC law firms will be putting together a macro in their laptops that just spit out major questions arguments, and they're right to do so from the perspective of advocacy, because the court has not clarified when the doctrine does not apply. So you might as well go big. But presumably there will be cases where the court kind of trims it back or says, when we said extraordinary, we mean extraordinary. A couple of major disputes or extremely prominent pieces of litigation where we're likely to see major questions be urged as a reason for rejecting agency action. The Securities and Exchange Commission is expected to come out with rules on climate risk disclosure in securities filings in the coming months, and the comments from some opponents of those rules suggest that they will be arguing that that's a major question, because you're turning securities regulation into environmental regulation, or imposing novel and far-reaching obligations on registrants. We already see the arguments made in Department of Labor rules under ERISA that have to do with the duty of loyalty and what managers of pension plans can consider in selecting plans and administering plans, and whether environmental and climate and environmental factors when they can be considered. Again, the major questions bell is being run in that litigation. And then in Clean Air Act litigation, there's already pending cases in the DC Circuit in which parties are arguing that EPA's incorporation or consideration of the potential to use electric vehicle technology as a means of emission control violates major questions, because it's a sweeping transformation, and it would be analogous to what EPA was trying to do in the Clean Power Plan. I think that one is tougher because there's the statutory language, for example, defining automobiles is pretty favorable to EPA's perspective. The entire auto industry is supporting what EPA is doing, and there is a long history of electric vehicle technologies being a means of emission control. But until courts kind of cabin this doctrine, it's going to be raised all the time. And so both agencies and advocates of environmental regulation have to be thinking about it and thinking of how do you sort of build a record that helps to defend against these kinds of attacks. And part of that is, doing a good statutory analysis to show that this is not a mouse hole. This is a broad, clear, often used agency authority, where it's possible to show that the administrative history supports this kind of action, or that there are precedents. That's important. And I know that agencies are kind of thinking about this, and the court's reliance on major questions now again will encourage them to continue doing that. Okay, I think just to close out, I'd love questions or comments. I think there remains just a great deal of uncertainty about this doctrine. It's really strong medicine. It kind of is a way of kind of blowing past sometimes close statutory analysis. And good lawyers can characterize, almost anything as, as big and novel. And so there is a risk that this doctrine could kind of like swamp traditional administrative law in a way that's extremely problematic if you think that those kinds of decisions, like whether we should roll back the administrative state, ought to be made by elected representatives, not by judges. I will note that there is a sort of complex and somewhat uncertain relationship between the major questions, doctrines, appearance as a Supreme Court doctrine, and the court's recent indications that it intends to either seriously downplay or actually overrule the traditional rule of deference to administrative agencies' interpretations of statutes associated with the Chevron decision. As many of you know, the court has granted cert in a case called Loper-Bright on whether to overturn Chevron. And so how does that relate to major questions? I think one could, I think in a lot of complex ways, a lot of the conservative critique of Chevron in recent, 10 plus years has been that the rule of judicial deference allows agencies to do extravagant things without judges sort of policing them. If there's a separate doctrine that is like directly targeted at those extravagant things, is there a need, or does that sort of undermine the case for revisiting Chevron? Maybe, but maybe if you're a judge who thinks that the administrative state and regulation is just sort of to be opposed at every turn, maybe you do both and get rid of both deference and keep an active major questions doctrine. But I think that that will be worth watching. And then I think that there will be a need, precisely because parties have an incentive to raise this all the time. I think the court will at some point need to create some guardrails, some limiting principles. We'll need to send a signal to lower courts that no, this is not just, does not put every regulation up for grabs. This does not forbid agencies from doing big and important things, because Congress has in thousands of instances directed them to do that. And so I think the court is going to have to take this up again. I think there will be a lot of sort of out there rulings in lower courts. And so I think we're gonna see more discussion of this doctrine and probably more ferment about what is the real rationale and what is its role to sort of, or what is its relationship to ordinary statutory construction in the coming years. And I think with that, I would love to see if there are any questions. Thank you for listening.
Thank you, Sean. That was awesome. So for the audience, we have a few minutes for you to ask questions, and you can enter your questions in the chat or comment space on YouTube or Facebook, and we'll get through as many as we can. But I'm happy to hog Sean's time with my own questions as well. So in the time since you gave your West Virginia talk last year, in addition to this litigation that you described, we also saw the release of proposed new regulations from the Biden administration, which rely on the same section of the Clean Air Act for authority, which is the section of the Clean Air Act that Justice Roberts referred to as a backwater in his majority opinion. So what reflections do you have on the new regulations, the wisdom of relying on the same part of the Clean Air Act? Did they have a choice? Yeah,
I mean, so there's a couple of different regulatory initiatives that will rely on Section 111, really important ones. One is for the oil and gas industry and methane emissions, which are, as folks know, one of our biggest sources of climate destabilizing pollution, very, very potent, massive amounts emitted in the oil and gas sector. And then also there will be a replacement for the Clean Power Plan that will presumably rely on sort of a different legal theory, and EPA has proposed an approach that's sort of more consistent with the sort of source by source technology based approach that the courts seem to think is traditional and kosher, but we'll see about that. I should note one big thing that happened that cuts in the opposite direction from much of what I've been talking about, which is deeply concerning for advocates of climate, federal climate protections. And that is the Inflation Reduction Act, which very comprehensively obviously provides massive funding for a lot of different climate initiatives, including in the power sector, but also includes various amendments to the Clean Air Act, including multiple provisions sort of incorporating the definition of greenhouse gas that emerged in the wake of Massachusetts versus EPA, and provisions like for the power sector in which Congress instructed EPA to ensure that it achieves sort of incremental reductions. That Congress recognizes that there's massive change and a lot of market-oriented or technology-oriented emission reductions already happening, but EPA is directed to use regulation to achieve more, including sort of the regulatory authorities of the Clean Air Act. So that's that language, which did not exist when West Virginia was decided, is very helpful in both atmospherically providing the signal that Congress is supporting climate action in multiple areas. Congress is spending lots of federal money on various forms of technology support and tax breaks, et cetera, that should lower the cost of pollution control, which is relevant to regulation because in many different sections of Clean Air Act instructs EPA to consider cost. So that's helpful. And then in some areas, and methane is a good example, the statute, the IRA, very specifically incorporates Section 111 regulation, including 111D existing source regulation. So that's extremely helpful. All that said, your question, what does the agency do when there's this signal of great skepticism? And I think the best that the agency can do is do as good a job as it possibly can on showing why the language supports what they're doing, the structure, the regulatory history, and sort of just do the best it can, and then advocate vigorously. And they may not win all of them, but they should win some of them. And to the extent courts are really kind of just blocking agencies from doing anything important, then I think that what remains is the opportunity for political objections, protests, politicking over that. And I think there is a sense that the court in a variety of areas, has gotten pretty aggressive. I should just briefly mention, I sort of adverted to it with West Virginia. There was serious question about whether they should have taken the case because it really was old news. They wanted to send a signal, and which, maybe that's an appropriate role for the court sometimes. But as everybody knows, in the Nebraska case as well, there's a really serious problem of jurisdiction and standing. And I think there are a lot of people who think that was actually the more troubling aspect of that decision. So anyway, so I think it's good that there's a lot of attention to what the court's doing. I think some of these developments, I think it's a good time to be an administrative law and environmental law student because it's forcing us to kind of rethink things. but it's definitely a fraught time to be an advocate.
If only there was some Supreme Court that could review the jurisdictional question of why the court took up this case in the first place, because it is odd.
Yeah.
Okay, question from the audience. They're wondering about the difference between Justices Barrett and Gorsuch. Could you elaborate on that and how it might affect how and when the doctrine might be applied?
Yeah, so Justice Barrett has written a lot when she was a law professor about substantive canons and sort of when they are justified and when they may not be, when they may operate to kind of inject courts into a role that they shouldn't play, and sort of overturning statutory interpretations that are the best reading or that the agency has adopted. And she, in her separate opinion in Nebraska, seems to make clear that there's no general principle that agencies can't do big things, and that if there were such a principle, that would be suspect as inconsistent with textualist principles and maybe just like made up. And that, so whereas Justice Gorsuch, again, believes that much of the legislation adopted since at least the 1930s is suspect, or at least subject to further inquiry under the non-delegation doctrine, that agencies are way too powerful and Congress has far too often abdicated its responsibility. And so that's just a pretty profound disagreement. And I don't think there's and that the Gundy decision where he wrote his big discussion of non-delegation is of note here. You know, it appears that there's not a majority on the court for a sort of really aggressive use of non-delegation. But this is one of those areas where there are important divisions within the six conservatives, and it looks like Justices Kavanaugh, Chief Justice Roberts, and Justice Barrett are the ones who are more skeptical about the more aggressive uses of this kind of doctrine. But they are themselves, you know, they're no fans of regulation, especially environmental regulation. So we're talking about a sort of triage kind of an analysis here from the perspective of environmental advocates. But those are the votes that are more likely to be there to uphold regulations where the agency has a strong statutory basis and appears to be acting in a way that is, you know, in their view, you know, moderate. So I expect they'll be the votes that people are looking at first in future cases.
Okay, I'm going to ask you one more question real quick, since all Clean Air Act questions can be dispensed with quickly. That's a joke.
Mhm.
So this question is, would using Clean Air Act Section 112 to set stricter health-based standards for pollutants such as mercury that are released along with greenhouse gases run into the major question doctrine issues?
I feel like I really did not plant this question, but I feel like it was, I'm very pleased that it was asked. So yeah, so that's the hazardous air pollutant provision that requires EPA to regulate pollutants like mercury and dozens of others, most of which are enumerated by Congress in the statute. And Section 112 is very kind of prescriptive and specific, and it's relatively rigorous. And I will note, perhaps it's no accident that as many folks watching may remember, there was a case called Michigan versus EPA a few years ago that involved Section 112 and a sort of weird provision that allowed or required EPA to decide whether regulating power plants under Section 112 was appropriate and necessary. And EPA had said, in deciding that question, we don't consider cost. And the Supreme Court said, yes, you do. That's crazy. Appropriate has to include cost. I note that on remand, went back and forth. The Obama administration said, okay, now we've considered cost and it's fine and it's appropriate. Mercury is really bad and a lot of these other pollutants are really bad. And then the Trump administration undid that and said, this is too costly. And then the Biden administration toggled back and said that it is appropriate. And that action of reinstating that rule or that finding was not challenged, which is so unusual in this day and age where everything is highly politicized and either red states versus blue states, and this was something that had already been at the Supreme Court. So I think it's partly because EPA did a really great job in explaining itself. But it may be partly that Section 112 really is, it is pretty specific, and I, the question also kind of gets at the idea. Well, is if the court is especially skeptical about climate regulation on the disputable theory that this is not what Congress was thinking about when it adopted Clean Air Act amendments. Maybe the thing to do is just vigorously enforce other controls on other types of pollution. I think there's something to that. At some point, you really need climate regulations, and again, the Inflation Reduction Act is extremely helpful there. But it's a great question. And there are even people who think Section 112 should be used to go after carbon as a hazardous air pollutant because the statutory definition is very broad. I think that there are a lot of problems with that theory once you get into sort of details and think about how a court would analyze it, but it's not crazy.
Yeah, the focus on health in 112 seems to have more of a political appetite as well. With so many of the other pollutants that are regulated there being harmful to the children and
and a sense of immediacy. It's
right.
not it's like the pollution from the smokestack to the victim, as opposed to going through this complex global atmospheric process.
Right. Okay, well, sadly, we're out of time. So thank you, Sean. That was a great presentation. Thank you, everyone, for joining us today. And our next talk will take place online next Tuesday. Hope to see you then.
Thanks.
Thanks.
Take care, everybody. Bye-bye.